partnering to some extent in hosting this event. Welcome to this afternoon's plenary on the International Criminal Court and Small States, the case for Trinidad and Tobago. We have a distinguished panel, very distinguished, and you permit me to start my introductions from the my extreme left, where Professor Brinsley Samaru sits. He is a senior research fellow at the University of Trinidad and Tobago, formerly at the University of the West Indies, and has published extensively on matters of constitutional reform and the Indian diaspora in the Caribbean. He is a former government minister. His prime minister is here and will be introduced later on. Happily, we do not have to take a report today on how he fared. Next to him, on his right, is Mr. Charles Leacock, the Director of Public Prosecutions in Barbados. He's a barrister, clearly, Master of Laws from McGill, and, pardon me, Hugh Wooding graduate. Hugh Wooding graduate. His Master of Laws is from King's College in London. And then immediately to his right is Mr. Duke Pollard, a former teacher of mine in history. He doesn't recall me now because it's more than 40 years ago. And memories do slip. But Duke Pollard is now a sitting judge of the CCJ, the Caribbean Court of Justice. He's a pioneer of that institution, and coming out of the CARICOM, that is. An expert jurist in international law, the law of the sea, the law of treaties, and many other disciplines in that area, so that we are proud to have him with us. And then, and this was saved for last because of my pride of being able to present him, Mr. Arthur Napoleon Raymond Robinson, who has had a distinguished life of service in Trinidad and Tobago, public service that is, crowned, I dare say, by being president of this country at one time. He may, however, prefer to say that it is in his fathering and proposing of the International Criminal Court that he saw his crowning glory, but I will leave that for him to determine. This, therefore, is our panel. And may I, at this stage, say to them that because of certain circumstances which would require one of us to leave, one of the panelists to leave immediately after 5:15, I should be asking them to limit their presentations to 10 minutes with a Trinidad time element allowed for maybe 1 or 2 thereafter. I wouldn't stand to tell them that time has come, but I will make a certainly distinguishable noise so that it will be easy to find out. I would want to start, if I could do so, with, and I forgot who I said to first, Mr. Leacock, was it you? No, it was Professor Samaru. And then we will come down in this order. So 10 minutes. Thank you very much. That will leave us ample time for questions. I am certain that the International Court of Justice has not been as much discussed in Trinidad as it ought to be, and so this is a fine opportunity for those of you who are keenly interested to have questions, and we will deal with the question and answer session. Thank you very much. Thank you, panel.
Thank you very much, Mr. Chairman. His Excellency Arthur N.R. Robinson, other distinguished members of the head table, ladies and gentlemen, colleagues. Yesterday, when he was giving his presentation, Ambassador Chris Hackett from Barbados enjoined us all to go and look at the very good display, I think, of the life and work of His Excellency Mr. A.N.R. Robinson. And I hope that most of you went and looked at it, because what I'm going to do is just to complement that exhibition by making some comments on the theme A.N.R. Robinson's long road to the International Criminal Court. In the year 2000, the then President of the Republic of Trinidad and Tobago, His Excellency Arthur N.R. Robinson, anticipating the establishment of the ICC, reminisced about his campaign for the setting up of that body. And I quote, "My own involvement in this matter has been long, and may I say arduous, but very exciting, having regard to the value of an institution such as an international criminal court for the implementation of international penal law and humanitarian law, in particular, in a very effective manner. End of the quotation. That struggle was indeed long and arduous, spanning just over half a century, culminating happily in the establishment of an international juridical organization which emerged just in time to act as a deterrent to increasing international terrorism, genocide, ethnic cleansing, and piracy. The long road to the ICC can be traced back to the early 1950s, when two bright young men crossed paths at Oxford University. In 1953, Robinson, having just been called to the bar in London, was admitted to read for the bachelor's degree in politics, philosophy, and economics at Oxford. He immediately joined the Oxford Union, that nursery for so many British and Commonwealth politicians, where he met and established rapport with another ardent debater, Robert Wurtzel, who was then writing a PhD thesis on the subject of the Nuremberg trials in international law. Prior to Robinson's arrival at Oxford, Wurtzel and others had formed the Oxford Political Society, to which Robinson was invited. This was the start of a long and fruitful relationship between the two men, which ended with Wurtzel's death in 1991. During this period, Robinson partnered Wurtzel in the long haul towards the ICC. In 1971, Wurtzel invited Robinson to a conference in Racine, Washington, whose purpose was the setting up of building blocks for the ICC. On that occasion, Robinson planted a blue spruce, which grew sturdily as the ICC also advanced. 3 decades later, when the ICC had become a reality, Robinson was invited once again, this time without Wurtzel, to celebrate the new birth. The spruce, a sapling in 1971, now a 30-foot specimen, overshadowed the gathering in April 2002. That evening, Robinson confided to his diary, "This was a most satisfying moment for me." And that spruce is part of the pictorial exhibition that is there in the library. When you go, you'll see the spruce still there. This successful establishment of the ICC was due in large measure to the harmonious relationship which developed between Robinson and Wurtzel. During the late 1970s, they had both shared fellowship at Harvard University, when much of the research work was done. When Robinson felt that his life was threatened during the run-up to the 1976 general elections in Trinbago, he appealed to Wurtzel to alert the international community. And just before his death, Wurtzel dedicated his last work, The Code of Talaries, to his longtime friend, Robinson. A second major influence on the road to the ICC was Robinson's time at Oxford. The young scholar interacted with eminent literati, such as the historian Max Beloff and the philosopher Isaiah Berlin, and he found time to interact with leaders of the Mau Mau struggle in Kenya, led by Jomo Kenyatta, himself a former activist in the UK. Robinson became actively involved in the debate about Europe's African colonies. In 1954, Robinson and other Afro-Asian people drew enormous inspiration from the Vietnamese defeat of the French forces at Dien Bien Phu and the forward movement of Asia under dynamic Asian leaders. And then in the next section, which I'll have to truncate considerably, I talk about the period in the Caribbean when Robinson was growing up and when he entered politics. This was a time when colonial peoples worldwide were breathing the fresh air after the long and dreary Second World War, which had provided a convenient European pretext for the withholding of political reforms in the Caribbean. Now, in the aftermath of the war, leaders were emerging to organize struggles everywhere. George Padmore, Kwame Nkrumah in Africa, Nehru and the followers of Gandhi in India, and Sukarno in Indonesia. In the Caribbean, there arose leaders such as Fidel Castro, Eric Williams, Norman Manley, Alexander Bustamante, Grantley Adams, Cheddi Jagan, and A.N.R. Robinson. Nelson Mandela, only 8 years older than Robinson, had blazed a trail for his generation by resorting to armed struggle, which resulted in lengthy trials from 56 to 61, followed by an equally long incarceration from 1962 to 1990. Caught in the spirit of the times, Robinson did not tarry long in the wings. In 1956, he joined Eric Williams to form the People's National Movement, serving as that party's first treasurer. In 1956, he had his first taste of electoral politics when he fought against Fargo, A.P.T. James, who had occupied the sole Tobago seat in the parliament from 1946. And now in 1956, Robinson was challenging him, and he was beaten by Fargo by just 240 votes. However, the Castara Kid, as Robinson was known, returned to beat Fargo in the general elections of 1958, and then in the federal elections for a seat in the federal parliament. After this election, Robinson was appointed Minister of Finance. In 1966, when there were 2 contestable seats in Tobago, Robinson won the Tobago East seat, after which he became Minister of External Affairs, a position which he held until 1970, when he broke with the PNM in the aftermath of the February Revolution of that year and the Army Revolt in April 1970. And then I go on to talk about Robinson's ascendancy until he became President of the Republic, a position which he held until March 2003. And I go on to talk about some of the real difficulties that he had. For example, in 1976, in the full public view, he was arrested and lodged in the Scarborough jail alongside 3 of his colleagues, and I was one of them. I shared a room in the prison for 2 nights with Mr. Robinson, and then we had to stand up in front of the Scarborough magistrate for 3 days to be interrogated. But then we were freed and compensated later on. And then another traumatic experience was the Muslimin coup of July 1990, where Robinson was a major target for those who tried to take over the government. The serious wounds sustained in July 1990 were to cause severe discomfort since that time. Such an example of the severity of that discomfort we have just seen. But in spite of these very traumatic, these events that would have crushed another politician, he used travel opportunities which ministerial office enabled to highlight the need for the ICC. At home, the subject was frequently mentioned, in and out of Parliament, as we shall presently see. At cabinet meetings, and I can attest to this, so often he would be talking at cabinet meetings between 1986 and 1991 about the urgency and the need for the ICC. And he identified his struggle for the ICC with Tobago. Both of these, he argued, the case for self-government in Tobago, both of which he argued were issues of human rights, and both were to be fought simultaneously. And then I go on to talk about the fora that he used, and the methods of agitation. Starting off with general ideas from the mid-1970s, he gradually honed his perspectives so that by the end of the century, he had become a leading authority on blue-collar crime worldwide and on various aspects of international criminality. Giving point to his research and his eagerness to establish the ICC were events such as the eruptions in the Balkans, characterized by the ascendancy of Milosevic, Karadzic, and Mladic, and their own peculiar ideas of national identity. The grisly stories of ethnic cleansing in Rwanda and Burundi were matters which deeply disturbed him, and I can stand testimony to that, and gave further urgency to his persistence. So this is the foreground to the thing, and I'll just read my conclusion. I've had to cut so much, Mr. Chairman. With the benefit of a short hindsight, because of the recency of the ICC, how can we assess this court's success? Like the UNO itself, its record is checkered with successful outcomes in Central Africa and at The Hague, for example. but serious hurdles remain, such as the continuing reluctance of the USA to join and the flouting of ICC directives in the Sudanese crisis, and my colleague who would follow me would speak precisely on this theme. Overall, however, the court has had a useful symbolic importance as an international warning authority, alerting would-be offenders that the international community is not prepared to sit by whilst human rights abuses flourish. There is even now a suggestion that the ICC should intervene in the aftermath of the Sri Lankan crisis. But whatever the international verdict, the Caribbean feels very proud of the role of a small island state in the establishment of the court. At the 4th Summit of the Association of Caribbean States, held in Panama City in July 2005, this region paid ample tribute to Robinson's role in this regard, and I would read just one paragraph from that document that was established in Panama City in July 2005, because it is part of the exhibition. So if you want to read the entire document, you should see it there. And we are very grateful to His Excellency for lending us so many of his precious documents which form part of that exhibition. And I quote from that CARICOM document: "In this respect, His Excellency Arthur N.R. Robinson is rightly regarded as a visionary for his proactive, indefatigable, and unswerving efforts to promote the creation of the International Criminal Court. From 1972 to 1987, he was a director of the Foundation for the Establishment of an International Criminal Court, and after his assumption of the office of Prime Minister of the Republic of Trinidad and Tobago in 1986, he was able to lead international efforts in the framework of the United Nations to lay the foundation for the establishment of the court. On July 17, 1998, with the adoption of the Rome Statute, the dream became reality, with the establishment of the ICC, with the power to exercise its jurisdiction over persons for the most serious crimes of international concern, including crimes against humanity. The establishment of the International Criminal Court, therefore, represents an historic landmark in the international criminal law and justice, as well as in international relations." End of the quotation. Thank you very much.
Thank you.
Distinguished guests, ladies and gentlemen, it's always a pleasure to be able to share with you a few thoughts on the International Criminal Court, as I had the good fortune to be involved in its deliberations since 1997. I've been asked to share some thoughts with you specifically on the issue of the first arrest warrant issued for the sitting head of state, that is President Omar al-Bashir of Sudan. The atrocities that have been witnessed and documented in Darfur in the Sudan have become the subject matter of the arrest warrant that was issued by the court. The brief history of the matter is that pursuant to the establishment of the paramilitary groups, namely the SMLA, the Sudanese Liberation Army, and the Movement for Justice and Equality, those two groups, along with other paramilitaries, but those are the principal groups, are aligned largely to some of the ethnic peoples in that region of Darfur, namely the Fur people, the Mazlet people, and the Zagwan people. And as a result of that, they have been organized and challenged the government of Sudan's authority in Darfur, seeking independence as so many other regions of the world, as it was recently done in Sri Lanka unsuccessfully. And because of that, the government they led a major attack against the airport in 2005, the Al-Fashir airport. And pursuant to that and the concerted attacks that they were doing of a military nature, the government of Sudan responded. The government of Sudan, as you know, has been headed by President al-Bashir since 1993, and they responded to those concerted attacks by deciding to launch a counterinsurgency in which a major or a core component of the counterinsurgency involved the attacks on the civilian populations, who were obviously the people aligned to the paramilitaries. And so they mobilized, the government of Sudan mobilized all their own paramilitary, the Janjaweed militia, as well as their national intelligence security services, the Sudanese armed forces, the Sudanese police force, and they conducted an insurgency which was characterized by attacks on the civilian population. It is with that background that the United Nations launched, under the former Secretary General Kofi Annan, Mr. Kofi Annan, launched an international inquiry, a commission of inquiry, and that commission reported back to the UN in 2005. It was the basis of that report and the Resolution 1564, upon which they reported back to the UN Security Council, that the Security Council, acting pursuant to Chapter 7, then issued Resolution 1594, which referred the matter to the International Criminal Court that was established on the 1st of July 2002. Now, based on the report and based on investigations conducted by the prosecutor, Mr. Luis Ocampo, and matters that are carefully documented, the prosecutor on the 14th of July 2008 requested an arrest warrant be issued for President al-Bashir. The court, sitting in pretrial chamber 1, consisting of judges from 3 judges, 1 from Latvia, 1 from Ghana, and 1 from Brazil, considered the evidence, and they requested additional information in about September of 2008. The additional information was provided in about November 2008, and we know on the 4th of March 2009, this year, the arrest warrant was issued. What is the significance of the arrest warrant, or even the request for the arrest warrant that was issued for the first sitting head of state? It is interesting and important for the following reason, in that it was the first time a sitting head of state has been called to account. The very statute in the preamble of the ICC requires an end to impunity. Perpetrators who commit such crimes must be called to account, and it's based on the irrelevance of their position. So a head of state who is usually entitled to immunities, both under national and international law, can no longer claim act of state and can no longer claim immunities. Those matters are all now irrelevant under the Statute of Rome, and it does not stop the court, subject to the checks and balances, namely the review of the prosecutor's request or even a propriamente investigation that is launched. It does not stop the court from issuing an arrest. So regardless of who you are now, the court is able to issue an arrest warrant. Now, Sudan is not a member of the International Criminal Court, and normally treaties or tribunals are bound by the state parties. So on what basis could the ICC issue an arrest warrant for a person like President al-Bashir, one, Sudan is not a state party to the ICC. The atrocities are not committed against nationals of a state party because they are people from the Sudan, and Sudan not being a state party. However, the court, the pretrial chamber, was able to hold that since the United Nations, acting pursuant to Chapter 7, had referred the matter, the Security Council had referred the matter to the court, it was under that basis that since the United Nations, under Chapter 7, has been conferred under the Charter of the United Nations with a responsibility for the maintenance of international peace and security, that it has the jurisdiction to issue the warrant against an individual who is not a member of a state party. So it was pursuant to Chapter 7 of the United Nations Charter that the court or the pretrial chamber has acted. And yesterday, during the Holmes lecture, we've heard views expressed that this might have some unfavorable consequences, in that a number of countries might wish to withdraw from it, or it might show the emperor as not wearing any clothes. I respectfully disagree with that view, for the simple reason that the International Criminal Court is a new actor on the stage. It imposes and calls to account persons personally. It imposes criminal liability on individuals, and as such, it has every right to act pursuant to the United Nations Charter, since it was the Charter and pursuant to Article 15b of the Rome Statute that the matter was referred to it. And moreover, not only was the prosecutor entitled to act, but he had the basis of doing so because there was overwhelming evidence. To date, the evidence is, the prosecutor's application has been filed ex parte, and it is secret. It's still confidential. But on the basis of the United Nations Commission's report that was referred to the court, and the other documented information consisting of thousands of documents that are in the possession of the prosecutor of the ICC, there is reasonable cause or reasonable grounds to believe that atrocities have been committed. And so an indictment containing 7 counts has been issued against President al-Bashir, namely 5 counts relating to crimes against humanity, namely the crimes of murder, extermination, forcible transfer of the civilian population, rape, and as regards crimes of war crimes, the 2 basic war crimes that he is facing under the indictment are the crimes of ordering systematic attacks against the civilian population and the pillaging of their property and of their villages, and that the war crimes are issued under Article 8 of the Rome Statute, and the crimes against humanity are contrary to Article 7 of the Statute of the International Criminal Court. So in short, President al-Bashir has been arrested based on good evidence, as we would say, and based on a proper legal basis. What has been the response? President al-Bashir has completely ignored the warrant, but what is the international responsibility of countries? Countries that are not members of the Security Council have an obligation under Chapter 7 to cooperate with the court. The ICC has no police force or no coercive powers. It relies on state cooperation to enforce its orders. And towards that end, all states that are party to the United Nations, that are bound by the Security Council, just as we are all bound by 1373 following the 9/11 events, we are equally bound to take action to comply with the orders of the court. So inasmuch as President al-Bashir has been able to thump his nose at the court so far and will not be surrendered by Sudan as long as he remains president, that is not the end of the story. An answer is found when we look at the other examples of ex-head of states who have been arrested. We look at the case of Pinochet, for example. The Spanish judges continued to issue arrest warrants against Pinochet, and even years after leaving office, while recovering from back surgery in England, the English authorities were able to arrest him. Rather than Karadzic, he was hiding for years and lived right under the eyes of NATO, but eventually he was betrayed and handed over to the authorities in The Hague for prosecution. So was Milosevic, who thought that he would never be taken alive, but he also was arrested, and despite the standoff lasting over 40 hours, he was brought to account. And quite contrary to his views that he thought he might have been tried only for local crimes of corruption and abuse of power, he was handed over to the authorities in The Hague, and we know he died during the trial in a Dutch jail. And last but not least, we have the case of Charles Taylor, the former Liberian president, who was comfortably residing in Nigeria with stacks and stacks of cash. But at the end of the day, due to international pressure and an outstanding warrant issued against him, when he sought to make it to the border with Nigeria and Cameroon, he was arrested after being identified by customs officials and handed over to Liberia. He was then transferred to The Hague, and he is today awaiting trial. So President al-Bashir might be able to run, but he cannot hide. The international community is right. It is a new order of business. There is a new ethos in international relations and international morality. And the perpetrators of serious atrocities and those who commit crimes against humanity and war crimes must be brought to account. If anything, the existence of the International Criminal Court will serve as a means to deter heads of state and those in commanding authority to think twice before they act, because they know that justice goes now beyond the national borders, beyond territorial integrity, beyond sovereignty. We are now accountable to an international jurisdiction which has real teeth, which has been successful so far, and which with time will continue to prosper and continue to ensure that justice is done, so that confidence in the international judicial system and confidence in justice worldwide will continue to prevail. I thank you.
Chairman, President Robinson, ladies and gentlemen, one of the ironies of history is that small states have played such an important role in enhancing the international legal order. You may wonder why this is so. You know, Africans have a statement: when elephants fight, or for that matter, play, the grass underfoot suffers. The small states in the international community are the grass underfoot. And we, therefore, have a primordial interest in the rule of law in the international community, which, from time to time, we get the impression is totally absent. The creation of the ICC was, in fact, a bold initiative in expanding the frontiers of international human rights law and international humanitarian law. But, however, the ICC, to my mind, has some shortcomings which hopefully in the future these will be addressed and corrected. You all know of the regime of the oceans, which was also spearheaded by a small state in the international community, Malta. What you have not known about, I suspect, is the role recently played by the little states of CARICOM in creating what you may call the most innovative international judicial institution in the world. And I think that the ICC can take a leaf out of the book of the Caribbean Court of Justice, on whose benches I sit. We have a court where the shadow of the state is not as dark as that which languishes on the ICC. We have a court whose institutional and individual independence is beyond question, whose funding is on a sustainable, independent basis, whose judges are not selected by the political surrogates of this world. We have open competition in the Caribbean Court of Justice for judgeships. Vacancies are advertised. The candidates are interviewed by an independent regional judicial and legal services commission. On the basis of performance, judges are selected. Funding of the court is achieved through a trust fund, where the CDB of the region was authorized to go out in the international capital markets, raise a loan of $100 million US, which was on lent to the small state of CARICOM, who did not see that money. It was put in the hands of trustees, the proceeds of which run the Caribbean Court of Justice. The judges of the court are not appointed by political surrogates. The only exception in this context is with respect to the president of the court, who must be elected by the heads of the government in a qualified vote on the recommendation of the Independent Services Commission. In our court, the shadow of the state is not so large, and the independence of its judges is beyond question. Now, if you compare this with the ICC, there are, I think, some troubling aspects of its composition and its administration. Now, for one thing, judges have to be sponsored by their states of nationality. And here there could be questions concerning their individual independence. They must also be elected by political surrogates. And here again, one may be able to question the independence of judges. Funding for the ICC is provided by states, parties into the regime. And you know exactly what that means. It means the states with economic clout will be those which could, in the ultimate analysis, influence the determination of the ICC. One of the more troubling aspects of the ICC, in my respectful submission, is the role of states in the administration of the court. You'll find it in Article 1112. The states exercise management supervision over the administration of the court. And in Article 1114 of that statute, the states are also entitled to create a watchdog committee to investigate, inspect, and evaluate the administration of the court. We all know what the rule of law, as we understand it, entails. It entails, first and foremost, that the powers of governance are shared between the executive, the legislature, and the judiciary, all more or less acting independently. In a situation, therefore, where states, entities in the exercise of their executive competence and can have oversight of the administration of a court, one will need to question the independence of such a court and the integrity of its institutional relationships. These, I think, are troubling aspects of the International Criminal Code, which should be advanced, which should be looked at in future developments of the court. And I am saying this not out of a lack of appreciation for the commendable achievements made in the establishment of the International Criminal Court. It clearly has enlarged the perspectives of international justice. It has clearly led to the investigation, prosecution, and conviction of perpetrators of some of the most heinous international crimes. And certainly, it has led to the relegation of immunity to the rubbish heap of history. But in spite of its achievements, I respectfully submit there is room for improvement, and I trust that with time, such improvement will be made. Thank you very much.
Thank you, Mr. Chairman. Through many perils and hundreds of miles, I have come from The Hague in the Netherlands, where I went and from where I returned about 3 days only ago. In fact, I did not think I would have been able to be present on this occasion, but it turned out that I was. I made the effort, and it succeeded. May I take the opportunity to say that I thank Dr. Samaru for the extensive tribute that he paid to me. But I really do not want the ICC to be reduced to the level of a single puny personality, as it has been many times by many other persons in many other places. I would not like such a great movement as the ICC to become involved in the envy, hatred, and other propensities of the human disposition. For it is, and I'm sure, not only my own opinion, one of the great humanitarian movements of the world, the ICC, with the entire system of justice in which it is involved. It is not merely a court, as some people think it is, or reduce it to the level of a single judicial institution. The ICC and what it represents is a humanitarian system, the like of which has not been seen for many centuries. Although there have been aspirations before the ICC itself. The fact that this system of justice, international justice, has become associated principally with an individual is, to my mind, unfortunate. For this ICC system represents the intelligence, the aspirations, and the imagination of thousands of individuals, and particularly of a smaller number of gifted but determined individuals who wanted to ensure that the world experienced a system of justice that would deter wrongdoers at whatever level of society or states, and bring persons who are accused of such wrongdoing to account by fair and speedy means of trial. After the Second World War, even such a great statesman as Winston Churchill agreed with Stalin of Russia that the Nazi war criminals accused as such should be shot without any trial whatever. It was the Americans under Roosevelt and Jackson, the Chief Justice, who was also prosecutor at Nuremberg, who insisted that they should be brought to account by rules which would stand for all time. The rule, the opinion of Roosevelt and Jackson prevailed. And that is how the Nuremberg trials came about. It was the Nazi war criminal Speer, Albert Speer, who said that rules have to be devised which would enable us to live together, because another war like this will result in the end of civilization. Today, another world war will most assuredly mean not only the end of civilization, possibly it can mean the end of life in the world. So that the example of the process that led to the creation of the system of justice around the ICC indicates the road forward in order to save mankind and possibly the world from this species and extinction. Anyone, therefore, who is inspired by the process that produced the ICC system of justice will, I'm sure, willingly cooperate in a movement to achieve the abolition of nuclear weapons. For the greatest threat of our time is the use of nuclear weapons, particularly by states, individuals, or rogue elements that do not care even about their own lives. It is therefore a matter of great encouragement that the United Nations is involved in promoting awareness of the system of justice represented by the ICC, but not the ICC alone, because in our vision of a court system, which normally is associated with the finding of guilt or innocence, those of us who were involved in conceptualizing the system of justice came to the view that justice could not be achieved within the narrow confines of guilt and innocence, but rather the victims of crimes should be considered. And so the statute that provides for the court also provides for a fund for the relief of victims of international crimes. There is a board which administers the fund. And when I thought that I had ended my career in international affairs, I had been invited to sit on that board. And that is how I came to be in the Netherlands, representing the Caribbean and Latin America, with others representing major geographical systems of the world. And I must say, how amazed I was at the work being done by those who administer the fund, which provides for the relief of hundreds of thousands of people, men and women and children, particularly women and children. I know of no other movement which has focused so much on the welfare of women and children as a fund for relief provided by the statute of the ICC. And that is one reason why I made the effort to travel to the Netherlands. For your information, I am 83 years old. I cannot read. I can hardly hear. I find great difficulty to walk. But one thing I know that I enjoy is the company of individuals such as members of this panel, my colleagues, and you who are present on this occasion and have made use of your time to hear the story. In a very truncated form, one would have much preferred to hear about the effort of many individual, visionary individuals, brilliant, excessively gifted individuals involved in the process. But this could not be compacted in the time available to us. What I can do is to give thanks to all of those who have been involved in the process for the effort, sometimes of great sacrifice, that they have made. And wish them the joy of the knowledge that it is all not for self, but in the cause of humanity. So let my message be in the cause of humanity. I thank you, Mr. Chairman.
May I now invite questions on the topic? It may be necessary to take some in clusters, but we will decide it as we go along, and we would leave it to the panelists to determine which question or questions they would wish to address. I will observe the 5:15 deadline very strictly. Very strictly. Thank you. First question then, sir. Oh, sorry, no. Pardon me. Forgive me, sir.
May I just chime in? First of all, to thank the panelists for a terrific end to our day in conference, a most inspiring group. But I wanted to make sure that Mr. Leacock didn't misunderstand the interchange between Bertie and me yesterday. This had nothing to do with an advance in international law. It was not a principled position we were taking. It was a tactical one. That is, it's wonderful that Milosevic died in the docket rather than in Nice enjoying his retirement. But the politics surrounding his indictment was, I think, totally different, because there was almost universal disapprobation. And as soon as that war was over, we knew he was going to be thrown into The Hague. The politics, it seems to me, in the Sudan are quite different. And our decision, it seems to me it's a myopic decision, or possibly politically myopic, in the sense that it may give a pretext to go back on the accord with the South, which is even more deadly than the war in Darfur. And second of all, it might undermine the fledgling criminal court if the result of the hollow threat turns out to be 15 or 20 African countries pulling out of the fledgling court. So it was certainly not a sort of a principled judgment. It was a political, tactical judgment by a political scientist.
Thank you very much, sir. Next question, sir. Gentleman in blue, yeah.
I want to thank His Excellency for an inspiring address, and simply to ask whether it will be possible to get the text of that message to spread to other people.
I think the answer is that there is some recording going on here, and probably the organizers may well address that in the very near future. Is there a third question? Okay, I'll keep that in mind.
Thank you very much, Mr. President. I hope you can hear me, because this is Bertie Ramcharan, and we used to attend together the meetings of the Foundation for the Establishment of an International Criminal Court, and I just want to say how inspired I was to hear you today. Now, having said that, as part of the history and the courage of Prime Minister Robinson, as he was at the time, when he became Prime Minister, his friend Robert Wurtzel activated the proposal that Trinidad moved to discuss the International Criminal Court idea in the General Assembly, was not well received by the major powers, especially the United States. And so if someone looks at the resolution that was drafted at the time and was adopted, it was deliberately crafted onto this resolution the idea of international criminal jurisdiction with particular regard to drugs and crime. So I just wanted to say that for the historical record. And at the time we used to call you Ray, President. And so Ray, may I say I'm so pleased to listen to you and to listen to what you had to say today. Now, if I may just go to this issue of Darfur. When Professor Weiss spoke yesterday, I deliberately didn't take him on this issue because I had other fires, other chestnuts to fry. I must say that I agree with Mr. Lee. I, as the High Commissioner for Human Rights, did the first report on human rights in Darfur. I presented it to the Security Council. And I found myself as a member of an international commission of inquiry, not the one you mentioned, a high-level panel. And I was in the borders of Sudan, of Darfur, in Chad there, and with a team. And I found myself thinking, the only thing that could possibly influence this situation is to indict some of these people. And therefore, I want to say, I say this not as a matter of instinct. And Tom, I respectfully disagree with you on this issue. Yeah, okay. I respectfully disagree with you. I think that he should come before the bench and he should take his case for justice there. So, Ray, heartiest congratulations, and so good to see you and to listen to you. Thank you.
Thank you.
Thank you very much. I understand what you're saying, Professor Weiss, but I respectfully also do not think that that's the correct approach. You're talking tactics, but the question is, if the court, by its nature, is going to think twice before it issues an indictment on the basis that a couple of countries might withdraw from its jurisdiction, I think that's the very reason that the court was set up. You cannot play politics with justice. There can be no peace without justice. And we must be forthright and we must be firm. So far, President Bashir might be able to even use the arrest warrant to galvanize support and to say, well, this is a Western imperialist Christian threat against him. But that is only going to last for so long, if ever he can. The distinction is that we must make the case clear that the warrant is not against Sudan or the people of Sudan. It's against al-Bashir. And as long as even the AU leaders recognize that, President Bashir will be isolated and he will be brought to account. I give you one other example. In the early days of the International Criminal Court, the Article 98 agreements were being signed by many countries with a certain northern power to confer immunity on their nationals. Barbados, a small island state, steadfastly refused to sign an Article 98 agreement, and we saw military assistance cut off to us. That lasted for a number of years. But we've come out of it now. Military assistance has been resumed under the new winds of change, and we're so much the better for it, and we took a principled stand. That is the approach I recommend.
Judge Pollard?
Yes, Rosina, concerning your question, I think that the political profile of states in the ICC could be reduced somewhat. For example, under Article 16 of the statute, the Security Council may defer the investigation or prosecution of an individual for 1 year, and that can be renewed, I suppose, ad infinitum. That could create the impression that we're the permanent members of the Security Council are in accord. They may do what they like in terms of issuing or deferring a prosecution. Secondly, I think that under Article 112B of the statute, the Assembly of States parties can exercise management control over the presidency, the prosecutor, and the registry. These are critical institutions in the court. And I myself am not so happy about this quality of control that states seem to be exercising over the court. As I said before, perceptions of the rule of law require a distribution of the powers of governance. And as far as practicable, these should not be overlapping. But you don't get this impression of an institutionally independent court in the ICC where the states can exercise so much control over the management of the court.
Thank you very much. I have a question for His Excellency, which really is whether it is his view that the Caribbean states are likely to find themselves before that court either as victims or accused at any time, having regard to the provisions of the treaty, of course.
I have not seen the evidence to support the view that they might be or should be brought before the court. They have been, what I would say about the Caribbean states is that the interest that was shown in the beginning by CARICOM seems to have waned, and that is most unfortunate, because CARICOM should have been seen always as having been playing and as having played a leading role, as indeed CARICOM did play. The matter could not have gone to the United Nations General Assembly without the support of CARICOM. It was CARICOM support that enabled it to be taken to the General Assembly of the United Nations. And since then, CARICOM has had a very low profile, very unfortunately in my view, for the people of CARICOM.
Thank you very much. Are there any questions? Yes, there's one here. Thank you.
Good afternoon. This is a question directed at His Excellency, Mr. Robinson. I found Mr. Pollard's comment on the apparent, perhaps lack of independence. I don't know if that's the right word I'm using, Mr. Pollard. The concerns expressed by Mr. Pollard about the neutrality then of the court. I wondered what are Mr. Robinson's views on that comment. If you could share your reaction to that comment with us, Mr. Robinson, I'd be very interested.
May I say that there has been no thought or belief among those of us who conceptualized the court that it could produce a perfect system of justice. And in fact, concessions had to be made. Concessions which would, in my view, fall short of the concept of justice in order to involve sufficient states in the process. You know, in the beginning, none of the larger states supported the court. It was only CARICOM and two other non-CARICOM states that supported the idea of the court. And as we progressed, we happened to have more support from countries like Canada and so on, larger countries. But this was only over a process of time. My own belief is that the larger states, including, let us say, the United States, will support the court. I happen to have been sitting with a member of the State Department by my side at one of these meetings, and being aware of the fact that I myself was being catapulted, as it were, into a leadership position, I turned to him and I asked, why doesn't the United States support the court? You know what he said to me? Well, you see, if we play a more prominent role, it will be said that we want to control the court. So we prefer a smaller state to promote the idea rather than we do it. Well, not a satisfactory answer to me, but that's what he said.
Is there any other question from the floor? Your Excellency, did America initiate the move to add drugs and crime as drugs rather as one of the other crimes which the court may look at? I had the impression that it wasn't initially meant to be included amongst the catalogue of crimes.
Well, for one thing, aggression was always within the contemplation of the United Nations system as one of the crimes which should not be condoned internationally. But the problem was trying to find a sort of a definition of aggression which could be generally accepted. And as you know, in the words of Professor H.L.A. Hart, a definition is primarily concerned with an enhanced awareness of words to sharpen the perception of phenomena. And the people who were involved in trying to define this term aggression could not agree. Because the Eastern European states were saying, you know, aggression comes from the Roman term aggredior, aggredi, aggressor sum. He who makes the first step must be deemed to be the aggressor. And the Western states, headed by the United States, would say, no, the question of animus is determinative. Unless you could establish animus, there can be no aggression. And the two sides simply could not look at that. I see the judge got a resolution, which apparently there is more on the principle of he who attacks first must be deemed to be the aggressor. But that's one issue which they could not really solve.
Oh, probably there's one? Yeah. Sure.
When the court started and when we were in Rome dealing with this, the original idea was to have drugs, and Trinidad and Tobago was extremely strong on recommending drugs. But then you had countries in Asia demanding that terrorism be included. But then that caused another problem as to definitions. And in as much as there are several definitions of aggression out there, because the United Nations have defined aggression in several areas. You have the Resolution 1314. There are several definitions of aggression existing, but the one that would have to be acceptable for the International Court has proven problematic, and the working group has been meeting on this for the longest while. And in fact, there is another meeting of the working group on the crime of aggression that's going to meet in Columbia University next week, still trying to hammer out a solution, and it is hoped that some resolution will go forward, at least to the review conference in Uganda in 2010. So there is work being done, and that it is for that reason that it was put in the, I think it's Article 124 or 120, whichever it is, that at the review conference coming up in 2010 in Uganda, the court will have to look at this business of whether to include drugs, terrorism, and aggression. But terrorism is as far as you can ever get, because at the UN, even after 9/11, you couldn't have a definition of terrorism. So that is dead, practically. And they're still trying with aggression and drug trafficking. The problem with drug trafficking has been it is felt that it should more be dealt with in the municipal courts. And so there may not be very broad spread support, much less consensus for it. So even drug trafficking at the review conference is hardly likely to be included. But we'll wait and see what happens in 2010 in Uganda.
Thank you. The other question in that area.
Good evening. I'm Lieutenant Colonel Anthony Philip Spencer. I wish to first express my appreciation for the deep sense of inspiration that I'm sure we all felt this evening, particularly, well, in all the presentations, but particularly in the comments of His Excellency President Robinson. Some people might know that I had the privilege professionally to work very closely with His Excellency during the period 1997 to 2003. And if you know the history, I'm sure you know the history of the court. So 1998 was one particular milestone, and then 2003 was another. And what I wanted to highlight and perhaps throw to the panel for their comments would be the fact that in advancing from 1998 to the actual establishment of the inauguration of the court in 2003, I witnessed His Excellency lead a mobilization of civil society NGOs. In fact, I heard one of the panelists refer to No Peace Without Justice, which in fact is an organization that became very involved in promoting the work of the ICC. And insofar as small states may not have in the international system the traditional political clout, there clearly seems to have been a lesson drawn from the process of the ICC, that within small states there is the capacity to mobilize the non-traditional forms of social power to help influence the outcome and promote advocacy for things that we would want to have advance in the United Nations system. And so I'm wondering whether it's a view that the panel would want to support as something that small states should adopt more aggressively in the way in which we engage in the United Nations system, that is engaging alongside of state-driven pursuit of its international political agenda, the involvement of civil society. In my presentation on the panel on 21st century security, I highlighted that one of the things that supported much of the advance in attempting to address threats, new and emerging threats to security, was the fact there was now a convergence of interests held by state actors with those interests held by non-state actors. And so in that regard, I think it might be something that we could pursue more aggressively, and I'd like to get some thoughts, if possible, from the panel. Thank you.
Thank you for your indulgence, Chair. Tim Shaw, your host. Let me echo everybody's very warm sentiments towards the previous President, Prime Minister, and also head of the Tobago Assembly. We're very honored to have you here, sir, and very much appreciate the effort and the consideration. I just want to ask a question about Uganda, because as some of you know, a few years ago I was a graduate student there. And Uganda, like Sudan, has led to controversies in the court over the LRA. And Mr. Museveni is a very wily leader. And when the Commonwealth decided to have its heads of government meeting there 2 years ago, unlike coming here, there was a major controversy about whether Uganda was democratic enough to be the host of the Commonwealth heads of government meeting. Let me just ask a question about whether, in a sense, it makes sense, given the controversy about the LRA, for the court to have accepted the hospitality of Mr. Museveni next year for the review process. Thank you.
Well, that was, as regards Uganda, that was really one of the very hotly contested issues at the last Assembly of State Parties as to whether we should accept their invitation. But it was felt that Uganda, being a situation country where there is actual problems on the ground, it might be useful for members to go there. But in accepting the invitation, we have also in the resolution made it abundantly clear that should the circumstances change by the time the conference will be moved. So I think, and the other reason is that another country had offered to hold it, Argentina. Initially it threw its hat in the ring and then withdrew and said only if Uganda cannot do it. So you were left basically with Uganda to accept, and it would have been most inappropriate not to accept the invitation at that stage. As regards the question of the role of civil society, I agree with you. I mean, whatever can be done to further the universality of the court, in fact, that's one of the basic roles of the NGOs, to further universality of the court, to get the court accepted worldwide. So far, there are about 110, 120 perhaps ratifications. I can't remember exactly off the top. But there are 120, thanks. And there are 192, 94 countries in the UN. So we have to get more and more countries to accept. And of course, recently, in the last 2 years, we had Japan joining on, and they have become the biggest financial contributor, so all the other countries are paying less contributions now. And that is the kind of snowball effect the court needs, to get the very big countries. The Nordic countries have been very good. Canada and the like-minded states have been very good in supporting it. But in as much as civil society has a role to further universality, that is the way to go, and we will continue to go, I'm sure.
Yeah, could I just make 2 points? First of all, one is that's slightly unrelated to what Mr. Philip Spencer asked, and that is that Mr. Robinson continues to remain as a consultant to the ICC, so that if there are ideas, and possibly this is one of the projects that ACUNS could undertake, as to how the ICC can be reformed in the manner that's being suggested by His Honor Justice Pollard, we could, I can give you the assurance that if these ideas are put forward, they will be read out to Mr. Robinson, and he understands, and he would say, well, this is what ought to be done with respect of this point, that point, the other point. In other words, I'm saying he's still very actively engaged as a consultant to the ICC, so that we should use his that current position to bring about reform in the ICC. And the other point that Mr. Philip Spencer raised is that a number of people in Trinidad and Tobago are now involved in setting up a study center, a research center, which is being named after Mr. Robinson in Castara in Tobago. And that institution is in fact being physically built as we speak. And one of the things you would find there, you and others who might be interested in looking at smaller states as well as civil society and their participation, there's a considerable amount of documentation that we now have, and which will be placed in the Robinson Center in Castara. For example, I remember seeing correspondence from Costa Rica and Vanuatu. And in the paper that I prepared here, I've given the names of a number of non-governmental organizations, stakeholders in civil society, who were very much involved with Mr. Robinson and the others in creating the ICC. So the point I'm making is that the information is not, hidden. It's very much there. And if others wish to do research on that line, the smaller states and civil society and how they participated in the creation of the ICC and how that participation could be furthered, how, in other words, that participation can be used as a model for further development.
Thank you, Mr. Chairman. I will be brief. My background is not in international relations, but as a person who is interested in what is happening in the world and reading from my father from time to time, I believe it was Robert Wilson's foundation that spoke about the ICC being important because there was a problem with determining who would try offenders for crimes committed on aircrafts and such. And I was thinking about what was happening in Somalia with the pirates, and I remember hearing that there was a problem with determining who would try the pirates, and very often the countries who would capture them would say they have no choice but to release them. And I was wondering if this was something that what the ICC would be able to handle similarly with regards to what Professor Wurzel's foundation was proposing for crimes, hijackings or whatnot on aircrafts.
For piracy, states have universal jurisdiction, which the ICC does not have. And that was the decision taken by the states parties, that the ICC would not have universal jurisdiction. So things like slavery and piracy, I think, are out. Thank you.
If I may say, the four core crimes of the ICC are basically war crimes, crimes against humanity, and genocide. And if we get a definition of aggression, then it will be. But the other way to deal with that, perhaps, is if your country were to submit a proposal for the review conference to have it included in the jurisdiction, it would be certainly something worthy of consideration, I'm sure.